The principle laid down by...
Okay, so the first thing to be noted is that clear and unambiguous language must be used. So, as Real Estate Agents Commission, the first thing to note is that clear and unambiguous words must be used. Something that is clear, that is not subject to dispute, must be used. Okay, so that's what the case of Luxor versus Cooper mentioned. So can anybody remember the phrase that was used in that case? What phrase was used in that case? What was the phrase used? What were the words used in that case? The case of Luxor versus Cooper. Does anybody remember? We need to move very fast.
On completion of the purchase.
Okay. What does that, I mean, what was to be done on the completion of the purchase?
The commission was to be paid on completion of the purchase.
And what did it call owed? What did it call owed? So nobody has read it. So that's, if people fail CT, they say it's the fault of the lecturer. It's a case that has been coming up at every point. So it's something that should be at the palm of your left hand now, but nobody can remember quickly. So when people fail CT, it is not the fault of the lecturer. So
it was held that...
Yes, I'm listening.
It was held that the suit could not succeed because there was no sale.
No, you are telling me I need to find out why. What can you just tell me? What did the court hold? Don't read for me. What did the court hold? You are in third year now.
Okay, it was held that in the case, it was held that since the contract states that on completion of the contract, the court held that the suit will not succeed.
You are still telling me the same vague, what did the court hold? You are still giving me the same phrase again, the same phrase. All I want is just simple words. You are telling me the same thing over and over again. What did the court hold?
The court held that the agents were not entitled to
Exactly.
commission for the sales of cinema.
Exactly. You are just reading. The other guy was just reading for me what. So I have to go and read it again. I'm asking, what did the court hold? You are reading for me exactly because you are just reading it now. You are just reading the notes. It's something you should have read. You should know it now. All the court held was that the agent was not entitled to his commission. Simple and clear. You are reading for me again and again and again what was in the note. This is not the way to pass law exam. You will read it immediately so that it will be part of you. This is why people fail the course. The court held that the case is not succeed. Why did the case not succeed? The court held that the case did not succeed. What exactly? Just simple word. The agent is not entitled to his commission. Simple and clear. Do I have to go and read it again? It's for your own good, not for my good. So, class captain, let's go ahead. So, if you don't know Luxor against Cooper, you are going to have problem in this course. As far as 40% of the marks of this course is concerned, if you don't know Luxor against Cooper, you are going to have problem in this case. If you don't know offer and acceptance in contract, you are going to fail contract. Nobody, whether you go to Mountain of Fire, you go to CAC or Top of the Mountain, it's something you need to know. It's just simple. It's as simple as that. So let's go ahead, please. Class captain, let's go ahead.
All right, sir. So the principle laid down by the House of Lords in that case is fully illustrated in the cases concerning this matter which came before the court since 1941. The first of these is Jones versus Lowe, 1945, all ER 194, where the agent was to be paid commission in the event of introducing a purchaser.
No. If you are reading something in quotation, you say quotation starts, and then when it ends, you say quotation ends, so that whoever is listening to you will know when you are paraphrasing and when you are reading quotation. So start again. The first case, start again.
All right. So the first of these is Jones versus Lowe. Quotation starts 1945. Quotations end.
No, forget. There's no quotation forget the citation. There's no quotation there. The first case, start again. The first case, quickly.
The first of these is Jones versus Lowe, 1945.
No, forget the citation. Forget the citation. Nobody needs citation.
The first of these is Jones versus Lowe, where the agent was to be paid commission in the event of quotation starts introducing a purchaser, quotations end. It was held, applying the Luxor case, that these words meant that the agent was only entitled to commission if he introduced someone who was not only ready and willing to purchase, but quotation starts goes so far as to sign a legal contract binding him through with the purchase, quotations end.
Okay, so in the first case, where the function of a real estate agent is to find a buyer or a tenant. The court is now saying that for the agent, in this Jones versus Lowe, where the words that were used was that, quote, in the event of introducing a purchaser. It's not just to bring somebody, oh, I brought Mr. Hay. Therefore, no. The court said no. You can bring anybody from the street. That won't give you the commission. The court said that the person that is introduced must be ready, must have the money or able to secure the credit, and will sign a binding contract that the person will complete the purchase. So it's not just to go and bring somebody. Oh, I brought Mr. B. I brought Mr. Obayemi. Therefore, no. That person that you have brought must sign. That means he must complete everything. He must be ready, able, and willing. He must be a good person that has the money, that has the financing, and that person must sign a binding contract. That is only upon then that the agent would be entitled to his commission. Does everybody understand what that case held? If you don't, let us talk about it now before we move on to the next case. Do you understand what the case held? Jones versus Lowe?
No,
what's it that you don't understand there? If you said no, what is it that you don't understand? Let's move on to the next case, please. Class captain.
Yes, sir. So this has not happened, and therefore the agent was not entitled to his commission. Okay. Similarly.
Okay, hold on. What did not happen in Jones versus Lowe? What did not happen, class captain? What did not happen? Are you there?
Yes, I'm here.
Do you want to read everything all over again?
Should I go ahead, sir?
Do you want to read everything all over again? Yes, go ahead.
All right, sir. So once again, the first of these is Jones v. Lowe, where the agent was to be paid commission in the event of quotation starts introducing a purchaser, quotations end. It was held applying the Luxor case that these words meant that the agent was only entitled to commission if he introduced someone who was not only ready and willing to purchase, but quotation start goes so far to sign a legal contract binding him through with the purchase, quotations end.
Go ahead.
All right. This had not happened, and therefore the agent was not entitled to his commission. So, similarly, in Murdoch-Lowney Limited versus Newman, the commission was to be paid, quotation start, in the event of business resulting, quotations end. The agent introduced a prospective purchaser with whom an agreement was made, subject to his being able to arrange a mortgage. That agreement was subsequently rescinded. Slade J concluded that the phrase was ambiguous.
Hello?
Hello, sir.
Yeah, hold on. This had not happened. Who's talking there? Who's talking there? Who's talking there? Okay, class captain, let's go back again. This had not happened.
Right, so this had not happened, and therefore the agent was not entitled to his commission.
And then I ask you again, what had not happened?
They did not.
Somebody's not muted there. Who is not muted? Can you find out the person? Who's not muted there?
Akimbele Titilayo.
And the person is talking. Who is that? Okay, this had not happened.
This had not happened, and therefore the agent was not entitled to his commission.
And we just want to be clear, what had not happened?
The fact that they did not introduce someone who was ready and willing to purchase, but goes as far as
you are repeating everything. What did not happen? You are repeating exactly. That's a mistake. From what you read, what did not happen? In simple words, what did not happen?
A legal contract of purchase has not happened.
No, what did not happen?
He did not introduce a purchaser.
No. What? No. Exactly. Just tell me simple word, like 3 words. What did not happen in this case?
The client wasn't a ready buyer.
The purchaser was not a ready buyer. Simple and clear. It's not to repeat what is in. It's to understand. It's to understand what the case. It's not to repeat. Anybody can cram and just throw it down. Anybody can cram. In simple words, the person that the agent brought was not ready. He didn't have the money, or he didn't sign the contract. And I said it is not only to bring somebody. I brought Mr. A, therefore I'm entitled to my commission. No, the purchaser that is brought must be ready to purchase the land and sign the contract. So in this case, from what is clear now, the person that was brought was not ready to buy. The fact that the agent brought somebody doesn't mean that agent will get the money. The purchaser must be somebody that's ready to pay for it and go on. It's simple word. It's not just to read what is there. It's to understand. Your mind must be going along with us. So in Jones versus Lau, the purchaser that was brought by the agent was not ready and willing to purchase and was not able to sign a binding contract. So the person that was brought was not a good person, was not a credit-worthy person. Therefore, the agent bringing a person, anybody, does not mean that he will get his commission. Does everybody understand what happened in Jones versus Lau? Or I should explain again.
Yes, sir.
Who does not understand what happened in Jones versus Lau?
So, please
explain again.
Who does not understand?
hello, sir.
I can hear you.
I don't, sir. Please kindly explain again, sir.
What don't you understand? What is it that you don't understand? We must tell me what you understand before I can explain.
Sir, please, I want to ask a question on this case. Sir, can you hear me, sir?
Do you understand what was held in the case first? That's my question.
Okay, sir. Yes, I understand what was held in the case, but I want
What was, hold on, if you understood what happened there.
on the holding.
I don't know. You are the one asking the question.
Okay.
If you say you understand, what do you understand?
Okay, from what is here in program, sir, the contract, sorry, the wordings of the agreement says that he would be paid commission in the event of introducing a purchaser. But when the court was interpreting what that phrase meant, the court held that the agent was not entitled to commission just because he introduced a purchaser or brought a purchaser or a buyer, but that buyer must be a ready buyer. He must be a willing and ready buyer. And like you said, it may mean having the money or being able to secure credit for the purpose of the sale. And after that, she should go ahead to sign a binding contract, to enter the contract, a formal contract. So that was
that exactly what was the case. Now, what's your question now?
So thank you, sir. My question is that is there a reason why the court interpreted it in this manner? Because the words of the agreement, they actually seem clear that introducing a purchaser. So is there a reason why the court added and interpreted it in this way?
No. Please, let's ask. Please, I like your question, but sometimes we need to ask questions that we are lawyers. We are almost in, if not for ASU break, you'll be in 400 level now. Okay? So
yes,
if I was the agent and I just grab you on the road, I say, yes, here is a purchaser. What does, and another person brings another person, here's a purchaser. What would that not be wasting the landlord's time?
Yes, sir.
Exactly now. So for you to get your commission, you must do something. Didn't we say it must be an effective, efficient, and the approximate cost of the deal which the landlord wanted? Wasn't that what we read last week? You must be the one that will cost. You must be the effective, efficient, and direct cost. Bringing just anybody, you have not done anything now. You just grab somebody on the road and say, hey, here's a purchaser. Give me my 1 million naira. The landlord will be throwing money away now. For you to get your commission, you must be the effective, efficient, and direct cost. So in this case, the reason why the court held was that the person that was brought and the act that was done by the agent was not any direct, effective. He hasn't conferred any benefit at all on the landlord. Any other? Let's go on to the next case, please. The next case is similarly. Thank you, Mr. Class Captain. I will leave you soon. Similarly, go ahead.
Similarly, in Murdoch Lowney Limited versus Newman, the commission was to be paid, quotation starts, in the event of business results in quotations, and the agent introduced a prospective purchaser with whom an agreement was made subject to his being able to arrange a mortgage. That agreement was subsequently rescinded. Slade J concluded that the phrase was ambiguous, and since it had been used by the agent, it could be construed contra preferentem. But that was held to be unnecessary in the light of the learned judge's conclusion that the words required a binding contract of purchase before commission was payable.
Okay.
Such a contract.
Yeah, go ahead, finish it, finish. Such a contract
had not resulted from the agent's act. Therefore, the house owner was not liable for any commission.
Okay. In this Murdoch case, Murdoch versus Newman, the phrase that was used was like quotation, quote, in the event of business resulting. Okay. The court held for 2 reasons. In this case, for 2 reasons. The agent was not entitled to his commission for 2 reasons. The first reason was based on the contra preferentem rule. if a person introduces an ambiguous word into a contract, that ambiguity will be interpreted against the person that introduced it. In this case, the word in the event of business resulting was held to be ambiguous. And because it was the agent that brought that word into that contract, it will be interpreted against him. Remember, in the case of Luxor versus Cooper, the issue was that the phrases used must be clear and unambiguous for the agent to be entitled to his commission. For that reason only, because the words used in Murdoch was ambiguous, it will be interpreted against the agent, and based on contract preferential rule, the person that introduced that phrase will be the one that will suffer the effect of the ambiguity. He was not entitled. Secondly, based on the previous case, that the Jones against Lau case, Jones versus Lau case, again, that what that phrase means that the person that was introduced must be willing, able, and ready, and then must sign a binding contract. For that second reason again, the agent was not entitled to his commission. So, in the case of Murdoch versus Lau, Murdoch versus Newman, the phrase that was used was that the agent was entitled to his commission in the event of business resulting. This meant, in this case, the agent was not entitled to the commission based on two reasons. Number one, the phrase used was ambiguous, and the authority of Luxor versus Cooper, where an ambiguous word is used, the agent will not be entitled to commission. And in this case, the person that brought that ambiguous statement into the contract was the agent. Therefore, it will be interpreted against him. Secondly, based on Jones versus Lau, when a phrase like this is used, it means that the agent must bring somebody who is ready, able, and willing, and able to sign a binding contract. In this case, there was no binding contract because the mortgage was not given. Therefore, the agent was not entitled to his commission. Does anybody have any question on the case of Murdoch versus Newman? Let me hear now before we move on to the next case.
Sir, please, I have a question.
Go ahead, ma.
Okay, sir, you said like the agent must be willing and ready.
No, not the agent. No, the agent.
I mean,
no. Madam, hold on. You are wrong. The agent does not have to be ready and willing. That's not what I said.
Yes, sir, I'm sorry. I meant the purchaser.
So you must use your word very well. Start again.
Sir, okay, you said the purchaser, like the purchaser that the agent brings must be willing and ready to buy. What about in situations whereby the purchaser is actually willing and ready to buy, but due to like other circumstances, maybe it's the principal that doesn't, maybe the principal doesn't cooperate.
You mean, okay, the principal? Yeah, the principal, okay. The seller, yeah, the seller.
Yes, doesn't cooperate, or maybe something goes wrong with the property. But then the agent, the purchaser was actually willing. He was like ready to actually make payments and conclude the contract. But then something went wrong along the way. So would we still say that the agent is not entitled to compensation when he actually got a
the agent will be entitled to the compensation? But let's go on to the next. That will be answered in the next case.
Okay, sir.
The agent will be entitled if it's the principal that is. The issue is this: the agent must have been the direct, efficient, and effective cause of the action that the principal wanted. Once he has done that, then it's entitled to his commission. Does anybody have a question on Murdoch versus Lau before we go on to the next case? So, okay, let's go on to the next case. Is in E.P. Nelson, Mr. Class Captain.
In E.P. Nelson and Co. versus Rolf, the agents were to earn their commission if they introduce quotation starts a person able, ready, and willing to purchase quotations and the principal's property. This they did, but before a contract was struck, the principal granted an option to purchase to another person introduced to him by other agents. He therefore refuses to deal with the other potential purchaser, and the agent sued for their commission. The Court of Appeal held that the agents had fulfilled the contract and were entitled to their commission.
So the woman who asked the question, do you understand now? In this case, the words were not ambiguous. It was the principal, the seller, that changed the goalpost after the match had started. The court held that the agent was entitled to his commission because in this case, the purchaser was able, willing, ready to complete, and he signed the agreement, and the agent has done exactly what he was asked to do. So it was for the principal who did not complete now. Does anybody have any question on E.P. Nelson? So we have looked at 4 cases today. We have looked at Luxor versus Cooper, Jones versus Lau, Murdoch versus Newman, E.P. Nelson versus Rolfe. So, Captain, can you take one more case for us? Captain.
Yes, I'm with you. The principles again.
You know I love you. Class captain, you know I love you.
Yes, sir.
Okay, so the principle.
The principles again were discussed in several other cases of the Court of Appeal in 1950. For example, in Graham versus Scott, Southgate Limited versus Oxlade, a commission was to be paid to the agent in the event of the agent introducing a person willing and able to purchase. Let me come again, sir.
No, it's okay. We don't worry. Go ahead. We hear you. Go ahead.
Okay. The agents were not entitled to commission where they introduced someone who offered to buy the principal's property, quotation starts, subject to contract, quotations end. The courts held that the mere introduction of a prospective purchaser was sufficient, but the purchaser at least had to make a firm offer, that is, one which did not leave him free to avoid completion without legal liability. In arriving at this decision, Cohen LJ distinguished E.P. Nelson and Co. versus Rolfe Supra on the ground that in this case, a firm offer had been made.
Okay, so do you understand what happened in Graham versus Oxlade? You understand? In this case, the agent brought somebody who was willing, able, and ready. But now this purchaser entered into an agreement that was subject to contract. I'm sure you people did contract last year. If you say subject to contract, what does that mean? It means that there's going to be another contract again. That person is not ready to sign the final contract. In this case, the principal is allowed to withdraw because the purchaser has not signed a binding contract. In the E.P. Nelson, the purchaser was ready to sign a binding contract. In Graham versus Oxlade, the purchaser did not sign a binding contract. He signed an agreement that was subject to contract. So there are 2 different things. Does anybody have any question about any of the cases that we have done so far before we move on? Please ask your question now. Please, I'm the one begging now. Before I start to mark you and give you 2/20.
Morning, sir.
Sorry, please, I have a question, sir.
Go ahead. What's your name?
Boy Misoke.
Boy Misoke, you be the one to read for us now.
Jesus.
Okay? No, okay. If you don't want to read, don't worry. We'll take another person. Any other question?
Okay, sir, can I ask my question?
Then don't swear with Jesus' name again.
Yes, sir.
Can you apologize to God? Say, Lord,
I'm sorry,
forgive
Jesus.
me.
Lord,
Exactly.
forgive me.
don't join other people that use Jesus' name flippantly. You can
Yes,
use my
sir.
own name flippantly. Olumide, call me anytime. But Jesus' name is bigger, like Anabi Muhammad SAW. It's not something you use anyhow. Now, what's your question?
I went online to check for the facts of the case of Jones versus Lau, and what I saw online was that the agent had found a person ready and anxious to purchase the
I lost
client's
you.
house. I
You went
went
online
online
to search.
for the facts of the case of Jones versus Lau,
Okay.
and what I saw was that the agent had found a person that was ready and anxious to purchase the client's house. But before contracts were entered into, the defendant withdrew the house from the market because the house prices had inflated.
No, you can't read your case within 2 minutes. You already want somebody else's. You already want somebody else paraphrasing. If you want to read the case, you go to the library and grab the case.
Yes, sir.
I'm sorry, Miss. I'm really sorry. You cannot read the case in 2 minutes. You are reading what somebody else is paraphrasing. It's like me now. I read the whole case. I read about, for example, if I read about Obi versus Tinubu, and I just say, a later acquired evidence cannot be used to, or I said you cannot gather evidence from the market. Like the judge held that you cannot get, but that's not everything that happened in Obi versus Tinubu. In Peter Obi versus Tinubu, they actually went to Chicago to go and get the result. There are so many things that happened in that case. The case that went to the district court about this, about that. So if I just say what that woman said, that judge, that cannot be the only holding in that case. So you can't rely on what somebody read, paraphrased. When the decision is given, there are so many things that are mentioned there. You only take the one that is relevant to your own position. So,
all right, sir.
are you, no, so you be the one to start now from, you're going to start at, where does it end? We're on page 50, we're on page 54. We're on, okay, we're similarly in McCullum. Okay, do you see that? Can you see that?
Yes, sir.
Okay, start for us. Boeing is okay.
Similarly, in McCallum versus Hicks, 1951.
No, forget the citation.
Okay. Yes, sir. So similarly, in McCallum versus Hicks, where the principal instructed the agents to find someone to buy his house, it was held that the expression was only a more colloquial way.
You hear what I said to the other guy? When you are quoting, we are looking at the words. That's what we're using now. So when you are looking at the words, say quotation start, and then when the quotation ends, say quotation ends. So we know the words that we are focusing on. Start again. Similarly, in McCallum, start again, please.
Yes, sir. Similarly, in McCallum versus Hicks, where the principal instructed the agents to, quotation starts, find someone to buy, quotation ends, his house, it was held that the expression was only a more colloquial way of saying, quotation starts, find a purchaser, quotation ends. Hence, no commission was payable, where the agents introduced someone who made an offer, quotation starts, subject to formal contract, quotation ends, but subsequently withdrew.
Okay,
Should I continue, sir?
Yeah, hold on. So the words used again, when the words are used, the most thing that the courts are now holding that when in a real estate agent, for the agent to be entitled to commission, the words must not be ambiguous, number one. If the words are ambiguous, then it will be interpreted against the person who put it there. In addition, for the agent to get the benefit of the contract, the agent must be somebody who is ready, willing, and able to complete the contract, and the person and the purchaser must at the same time be ready to enter into firm binding contract. In this case, the purchaser said he only signed an agreement, made an offer subject to another formal contract. The court held that purchaser is not ready to enter into firm binding contract. Therefore, the agent is not entitled to commission. Do you understand what happened in that case? Does anybody have any question on any of the cases you have done so far? Please ask now, because this is coming out in exam. You must be able to locate, you must be able to locate the ambiguous word. You must start with Luxor versus Cooper. You must start with wait. Can you hear me now? Can you hear me? Can you hear me?
Yes, sir.
Can you hear me now?
Yes, sir. Yes,
okay.
Sir.
This area is coming out in exam, whether you like it or not.
Okay, I'm praying.
You are praying.
Yes,
Okay,
yes.
sir, I
Are
have
you
a
praying?
question.
The Lord
Are you
has
praying?
granted your prayer. It will come out in exam. Amen. Now, if you must start from Luxor versus Cooper.
So I have
And
a question.
what that says is that
Who came for birthday party?
What that case says is that
happy
words must be unambiguous.
birthday to you. Happy birthday, happy birthday. Happy birthday to you. I wish you longer and prosperity.
Who is that? Who was that singing happy birthday now? Please, who was that? Okay. So going is okay. Let's go on. The same result was in which in Dennis Reed. Can you go ahead, please?
Yes, sir.
I have a question,
So I have a question.
The same result was reached in Dennis Reed. Please, can you go ahead?
Yes, sir. The same result was reached in Dennis Reed versus Goody. The importance of this case, however, lies in the formation by Denin LJ of the General Law on Estate Agents Commission, which provides the background for the interpretation of an estate agent's contract with its principal. Friedman summarizes this principle in the following points.
Hold on, please. Hold on.
Yes,
so
sir.
Everything we have done so far has been summarized in all these 6 points. So everything is now about whether the agent is entitled to commission. So read it, and then we go to the question that I just sent online. Go ahead.
All right. So number one, the agent is only to receive commission if he succeeds in effecting a sale. Number two, any language that is used.
The agent is only entitled to commission if he's able to effect a sale. That means it must be the effective, efficient, and direct cost of effecting the sale. Number two, go ahead.
Number two, any language that is used in the contract will have this effect as long as it shows that the agent is to introduce a purchaser.
Any language that is used will have this effect as long as the agent, that means Jones against law, the agent must introduce a purchaser who is able, willing, and ready to purchase. Go ahead. Number three.
Number three, if the agent is to be given commission on offers only, he must use clear and unequivocal language.
If the agent is only, if he's only just going to get his commission, if you only introduce offers only, the words must be very clear. Luxor versus Cooper. If the words are not clear, Bow is not getting anything. Number four.
Number four, the normal arrangement. Number four, the normal arrangement, common understanding of men. Quotation open is that the agent's commission is payable out of the purchase price. Quotation closed.
Okay, that one is okay. Yes.
Number five, if a binding contract of purchase is signed by the principal and the third party, if a binding contract of purchase is signed by the principal and the third party, then if the principal repudiates the contract, he is still liable to pay commission, not because it has been earned and is payable, but because it is his own fault that the sale has not been completed.
Okay, that is E.P. Nelson versus Rolf. In that case, the agent has done everything that was necessary for the agent. He has done everything. He has introduced a firm, willing, and able purchaser. So if the principal now refuses the agent will still be entitled to his commission because the agent has done. EP Nelson versus Ruff. Number 6.
Number 6, but no commission is payable if it is in the third party, not the principal who has defaulted on a binding contract, unless the principal sues for specific performance and gets damages, in which event he will probably be liable to pay the commission out of such damages.
Okay? If it is the third party that refuses, like Graham versus Oakslade and is it Murdoch versus Newman, then the agent is not entitled to commission because he has not introduced a binding, and willing and able. But if the principal sues the third party for breach of contract and so now gets his money, then the principal is obligated to pay the agent from that of the money that was earned. So that finishes everything. Before you ask any question, did you Boom is okay. I like your voice. Now, did you get?
Thank you, sir.
Can you open your WhatsApp message, please? Did you get the question that was sent by the class captain today?
Yes, sir.
Okay, let's go to question number 4. In that question number 4. What year is this question?
2019, 2020.
Okay, 2019, 2020. Let's go to question number 4, please. Can you read?
Okay,
4? Yes.
Ade engaged Olu to negotiate the sale of property with a 1 million naira commission. 1 million naira commission was to be paid to Olu, quotation open, on completion of the purchase, quotation close.
Hold on.
Offers...
Hold on. What
Yes,
case
sir.
is that? In which case was that used? Can anybody answer? You can unmute. Are you there? Is everybody there?
Luxo is Bond Ltd versus Cooper.
And what was the decision in that case?
The agent was not entitled to commission.
So as soon as you see that, what do you write on the question? What do you write as soon as you see that phrase? What do you write in to make a note that you are reading the exam? What you write Luxo versus Cooper. So go ahead, Miss Boy, Miss okay.
Yes, sir. Offers were secured for the properties, but the agreement made with the purchasers was expressed to be quotation open, subject to contract, quotation closed.
So subject to contract, the purchaser says subject to contract. What case is that?
Graham
What case is that?
Graham
versus Oxlade. And
so what does that tell you now about that purchaser? Is he ready, able, and willing to purchase?
No, it's not ready and willing purchaser.
Okay, go ahead, Miss. Go ahead, Miss Boy, Miss okay. Go ahead.
A binding agreement between Ade and the purchaser was not completed because Ade decided not to sell. That's already
Ade decided not to sell. So what does that tell you? Is Ade the seller? Is he entitled to withdraw? Is Ade entitled to withdraw?
No, sir, I do not think so because there was no firm offer since the contract, the purchase was subject to contract, or the agreement was subject to contract.
Did you hear my question? Did
Sorry,
you hear my
sir.
question? Did you hear? I said, was Ade entitled to withdraw? Do you know who Ade is in this case?
Yes,
sir, he's entitled to withdraw.
Yes, sir, he's entitled to withdraw.
So what was, you see how people fail exam? Can you see how people fail exam? She's arguing against herself. Is it my fault now? If I give her 0 in exam, is it my fault? Can somebody answer? Is it my fault if I give her 0?
No, sir.
Whose fault is it?
Your fault.
Okay. Thank you very much. Then they will start writing a petition. I did everything very well. Are you still there? Can you hear me?
Sir.
Okay, something came up on my laptop. That's why I'm asking. It says allow something or something like that. Now, oh yeah, A. Boom is okay.
A, what should Olu do?
So what should Olu do now? Anyway, we have identified the issues anyway. So you should identify the issues and then your conclusion will be what would. So what about B?
B. Would the result be different if the contract between Ade and Olu had stated that Olu would be entitled to commission in the event of introducing a purchaser, in the event of quotation open, introducing a purchaser, quotation closed?
Okay. In which case was the inventor introducing a purchaser? In which case was that used?
Just versus.
Okay. So would it all be different?
No, sir, it won't be different.
Why? Why not?
Because in that case,
In which case? Not in that case. In which case? In that case. In which case?
In Jones versus Lorry, the court interpreted introducing a purchaser to mean introducing a ready and willing buyer, someone that is ready to pay for it.
So in this, then also go ahead.
But in this case in question,
in which case? In this case, in which case now? Go ahead.
In the scenario between Ade and Olu,
exactly.
The purchaser was not a ready and willing buyer. It was bringing in another contract. It was making the already existing contract.
So let's go to C. Let's go to C. Mr. Egboim is okay.
Yes. Assume further that Ade and Olu decided to amend their contract to state that the commission was to be paid, quotation open, in the event of business resulting, quotation closed. And Olu introduced a prospective purchaser with whom an agreement was made, subject to his being able to arrange a mortgage, which he could not arrange, and by reason of which the purchase agreement was subsequently rescinded. Is Olu entitled to commission?
Yes. Who wants to answer that? In which case was that? In which case was that? In which was that phrase used?
In the case of Murdoch Lowney and a Newman, so there'll be no so there won't be binding contracts because the purchaser was unable to acquire a mortgage.
Okay. Okay, let's go to 5. Let me see if you have done this. Okay.
It will be contracted non-so to purchase a Toyota Highlander 2021 model for him for the sum of 20 million naira. Nonso decided to purchase a Hilux instead. Further, without telling Ebube, Nonso engaged Rasta to buy the Hilux from Cotonou. Rasta was able to buy.
So, yes, what can you see so far? What can you see so far? Hello? What's time now? Because I need to get out of here too. Nobody. What can you see so far?
Duties of an agent.
What?
Delegation.
What? One person. What? What did you see?
I think duties of an.
Okay, you are breaking up. What?
I believe we can see that the agent has not met the and
the agent has what?
Not. I say we can see that the agent has not met the requirements.
The agent has not what?
Has not met the requirements of what the
requirement? Does anybody wants to answer me intelligently, please?
Yes, I believe that the terms of the contract has not been met in the sense that the agent is going out to buy an Hilux instead of the
Does anybody want to answer the question clearly?
So I think the agent is going beyond his powers.
Sir?
I think the agent is going beyond his power.
What do you say?
I think the agent is going beyond his power.
I didn't hear you, sir. What do you say?
I said I think the agent is going beyond his power.
So nobody has been reading the materials. Okay.
So I think the agent has not performed.
He has breached. What duty is that?
The agent has not
performed now.
Obedience. Obedience, sir.
What?
He breached his duty to obey the express instruction given by the principal.
Let's go ahead so I came to school just with the internet here. I think I'm not dealing with people. Yeah, go ahead. So, Mr. Egboim, okay, go ahead.
Rasta was able to buy a very excellent vehicle with a fair market value of 25 million naira for 10 million naira. Both Nonso and Rasta shared the 10 million balance which Ebube had paid in advance.
Okay. So what can you see now? Do you see any duty of obedience, duty of performance, duty of loyalty, duty not to delegate, seeking profit, fidelity? So what does Mr. Bube? Miss Boynis, okay, just sorry.
Yes, sir. Advise Ebube on these transactions.
Yes.
B, is not so permitted to engage Rasta at all. C, can Rasta recover commission from Ebube?
Okay, the C one is the one we would deal with next class. Okay, so if you are not for the way to answer to read law questions, and I keep telling people it's not to read on the last day of the exam, it's to read as the things are going. You should have known duty of obedience, duty of performance, duty of loyalty, duty of care and skill, and all that now. You should have spotted everything quickly now. And when to delegate, when not to delegate, when is that, when is this, commission, secret commission, and all that, anything above normal commission. So I will see you on Monday at 11 o'clock. Thank you very much.